Welcome and good evening. Thanks for joining us. This evening, I will do an introduction about myself and also how we got started with Liz Smith Law. And then if you want to share anything about yourself, what brought you here, you're welcome to do so in the chat. And then I'll cover some general ideas about what would happen to your stuff upon your death, some guidelines about what happens in Alaska, what the state's plan would be if you have no plan in place, talk a bit about probate, what that looks like, cover some of the different planning tools. And then I'll cover what you would want in place if you became incapacitated and couldn't make your own financial or healthcare decisions. I'll talk about some of the free tools available, share my opinion on when I think you should talk to a lawyer, and then open it up for questions. So I am Liz Smith. I moved to Juneau around 2005 with my now husband. And then a couple of years later, I left to attend law school in Vermont before returning in 2010. I then worked for the state in a variety of jobs at the public defender's office for a while, including up in Barrow, and then for the Department of Law. But after about 10 years working for the state, I knew I was ready for a change. Attorneys often work a lot in conflict. It's kind of our job, but it's not a lot of fun. A lot of people leave the legal profession for that reason. I also knew I wanted to work with people in a more personal capacity than I was doing. And I had started in 2017 a health coaching business, which allowed me to realize how much I loved working with individuals on their particular health goals, but also how much I loved running the business side of things. At that time, I thought that private practice wasn't something I was remotely interested in terms of continuing using my legal degree. So I knew if I was going to start a practice and think about going that route, that it was going to be something I was very conscientious about in terms of the decisions I made for the practice, and that I wanted to do something different. For one, I had been a client before of an attorney, and I was extremely frustrated by the billable hours. If you've ever worked with an attorney who charges a very high hourly rate, I knew when I asked the attorney a question, I really wasn't sure if it was going to take her 10 minutes because she already knew the answer, or if I would get charged for 10 hours of her researching to find the answer. I also discovered that as a client with a billable hour practice, you don't want to ask questions of the attorney that you don't think are vital because you're going to be spending more of their time. And of course, if the attorney starts engaging you in any chit chat or asking about your family, you might feel that they're more interested in making money than actually hearing about you. So I didn't think that that was a good dynamic for attorneys or clients. And then I knew I wanted to be conscious about the people I worked with and the type of work I did. So I thought and decided to choose estate planning. And as I considered that route and what that would look like, I started asking friends and family about their experience of what worked and what didn't work. I have a friend whose father paid over $4,000 for his estate plan to make sure that his kids stayed out of court upon his death. And yet, when he died, his kids were multiple years in court and had to fight with the ex-wife. My friend thought that must be malpractice, only to ask around and learn that what the attorney did was common practice. There was a lack of follow-through. On the contrary, my grandparents hired an attorney that they met with regularly over many decades, making changes to their plan as life circumstances changed. They also introduced their daughter to their attorney. This is my aunt and the person who later served as the trustee upon their incapacity and their death. This meant my aunt knew the attorney when her parents died and had a relationship and trust already built up. So she turned to the attorney for guidance in handling the estate, and it went relatively quickly and smoothly, and she did stay out of court. So you'll see and hear more about how we do things differently, but I just wanted to highlight some of the reasons that we make decisions the way that we do and the way that we practice. At Liz Smith Law, which we started in 2019. And we serve only estate planning clients, do the post-death administration, and then I work with a select number of businesses. And this focus allows us to better serve clients in those specific areas. We do entirely flat fee billing. So if you work with us, you know ahead of time exactly what your fee is going to be, and you can plan on it and ask those questions, even if they might not be, you might not think they're important, but might be curious. And then we have a team and systems in place. So if someone expresses interest in working with us, we really do our best to help you through that process if you just do express interest, so that you get to the finish line and have documents signed. I've worked with a number of people who have worked with an attorney, gotten their plan drafted, and then never signed, or somewhere stalled out along the process. And then with the people we have in place, it also means that we're able to follow through with changes. So when we talk about estate planning, which we'll get into in much more detail, there's always other side pieces to your planning, such as beneficiary designations. We also offer a free review at least every 3 years, so your plan stays up to date with your life and the law. And then we have a modest membership program for clients that want annual updates. That's a bit about myself and our practice. On a more personal note, I am married. You can see us together. We love to travel, and we have 2 lovely dogs, potentially both on their last legs. So we're going through that at the moment. And my main hobby is triathlon, which I love. And I am sad that we don't have Ironman Alaska anymore, but that's another story. I wrote a book as a health coach, and that's this picture here is myself in the fireworks gallery. Okay, let's move on and get into the estate planning. If you'd like to share anything about you and what brings you here, feel free to put a note in the chat to everyone or to myself, just to give me an idea of what might be important to you and where you're coming from. In the meantime, I want to make clear that while I am an attorney, I'm not your attorney, unless we have a written attorney engagement agreement. And what that means, or the point is that I am providing information very general and not specific to your situation. At the end, I will tell you how to get information specific for you. Why are you here today? And Alex just shared a note in the chat so that you could, well, actually, if you reply to her, it would be everyone, but now you see how her name is listed. So why are you here this evening? Did you come to get the total assurance and comfort knowing your family would be taken care of in the way you want if something happened to you? Or maybe for the peace of mind, knowing what would happen to your assets at your death? Or did you come to make sure that your family didn't pay estate taxes unnecessarily? Maybe you came to make sure that you'd be taken care of in the best way possible, and that the decisions you want would be made for you if you become incapacitated. These are all great reasons to be here today, because you'll learn what you need to do to have the peace of mind knowing you've made the right decisions for your family during your lifetime, so that at your death, things are as easy as possible for the people you love the most. So let's start by talking about what the state's plan would be for you if you die without any plan at all. And that plan is typically called probate. Probate is the court's process after death to transfer any assets in your name to whomever is going to inherit them. It's basically a lawsuit, or a lawsuit you file against yourself with your own money for the benefit of creditors. That's a bit tongue-in-cheek. You would, of course, be deceased. But in that court's process, someone comes forward as personal representative. So if you don't have a plan, then there's a statute that says who would have priority. If you're married, your spouse has priority to serve as personal representative. That's pretty straightforward. If you are not married and have adult children, they all have equal priority. So that means that if they can all decide amongst themselves who's going to serve, then that will be relatively easy. If they disagree, then the judge is going to have to decide, which is going to be a huge delay and very costly. that person's role, once they're appointed, is a huge role. It's a lot of work and also a lot of power. They are charged with gathering the assets and then distributing to whomever's going to inherit. They can get paid for their time doing that. In fact, they, by statute, they will have to have the option. They don't have to take it. So you can think in your own life, is it clear who would serve? Or is it possible people would fight over it? Or possible no one would step up? That individual who's the personal representative may have to post a bond, and that can be challenging for some if they don't have the financial background to get the bond. The process of probate before assets are transferred takes at least 6 months, but usually it takes more like 12 to 18 months, even if the personal representative and everyone is moving quite smoothly. There is a period to notify creditors and publish in a paper. It's also a public process. So when I say a lawsuit, it's a lawsuit, and it's as most lawsuits, everything that's filed becomes public record, and someone can look at it and get a sense of who's inheriting what potentially. If you have a minor, or talking about who's going to inherit, if you have no plan in place, no will or anything, then again, there's a statute that says who's going to inherit. Sometimes that makes sense and might line up with exactly what you want. Sometimes it can surprise people. So let's say you're married and have joint children, then the spouse will inherit. And after and then if there are the second spouse to die, or the second person to die, assets would go to the children and be divided equally amongst them. So that probably makes sense to you. If there is a married couple and they do not have children, and one of them dies, then that individual's parents are going to have a right to inherit if they're still living, and the spouse will get a portion as well. That one can trip people up, seems a bit odd, but that's how the legislature wrote the law. And then if there are children from a prior relationship, so it's a blended family, when one spouse dies, their children have a right to inherit right away. Not everything would default to the surviving spouse. There's a lot of nuance in statute in terms of your particular situation, but that's just to give you an idea that there is something written in, and it might not be what you expected. Now, in Alaska, you can file something with the court and not have to go through the lengthy court process if certain conditions are met. There are 3 conditions, and they all must be met. So first, if you do not own a house or other real property. Secondly, if the vehicles you own are worth $100,000 or less. And third, if the entire value of your assets are $50,000 or less. Now that third one, what we're talking about there are assets other than vehicles and real property, and the assets that pass through probate. So let's say you have no property, you have $20,000 in vehicles, and you have $20,000 in your bank account, and then you have a $200,000 retirement account. Well, the retirement account probably has a beneficiary listed and will go straight to them. So then you would actually not go through probate in that situation, because you would just have $20,000 in the value of assets in this third bullet. All right. Now, if you don't meet those 3 criteria and you didn't like the sound of probate and wouldn't want your family to go through that, a will does not avoid probate. A fully funded living trust does. That's a common misperception. I'll come back to the great advantages of a will and talk more about a trust and their advantages as well in just a moment. But first, I wanted to cover a state tax if you are concerned about paying it. The state tax is a tax on a deceased person's assets. However, there's always some amount excluded. In Alaska, we do not have a state tax. If you are an Alaska resident and you have property in another state, such as Washington or Oregon, those states both do have their own estate tax, and that's going to attach to any property in that state. So that could be important to monitor. Otherwise, if you're an Alaska resident, we don't have a state estate tax, but we are subject to the federal estate tax. It's a very high tax rate, but it's only owed if your estate at death is worth more than whatever the exemption amount is. So the exemption amount means if you die below that amount, you don't owe any estate tax at all. That exemption amount changes over time. I can't tell you what it will be upon your death because it will probably be different than today, but I can tell you that the estate tax exemption amount right now is over $12 million per person. So most people aren't too concerned, but it's important to watch. It will come down even if the legislature does nothing in 2026. So it can be important to have your eye on it. And part of the reason I bring it up is because there's some easy planning to avoid it if you're anywhere near at a threshold. When we talk about estate tax, this slide is meant to show that when I talked about what assets go through probate, that's different than what's going to be calculated for estate tax. So any life insurance, retirement assets that pass to the beneficiaries directly would be considered. But then we're looking only at equity value for anything like a home with a mortgage. So let's talk about some of those different planning tools. I covered a bit about what the state's plan might look like for you if you have no plan in place. So what does a will do? It can keep your family out of conflict. You're deciding who you want to be your personal representative, and you're deciding who's going to get what and when. So that can help avoid conflict. You have control to decide something different than what the statute says. It's certainly a perfect vehicle if you're going to avoid probate anyway, based on your assets, or maybe for starting out. You could face probate depending on your assets again. A will is important if you have minor children, to name who you would want to be guardians for them. So a will can be a great tool. Just know that it still involves probate, and it's a bit less, the will's only going to cover those assets that go through probate. So with a will, sometimes when people have a bit more complication in their assets, a will can make it more complicated, whereas a living trust can be more fluid in terms of keeping everything together. So what is a living trust? A living trust is an entity, in essence, that owns your assets. So just like a business can own certain assets, so can a living trust. The thing with a living trust is that you own them during your lifetime as you're the trustee, which means you're managing your assets. So when someone sets up a living trust, they don't see a change in terms of their day-to-day control of assets. It's a little more work to set up than a will. But then you still have control until you lose it because you are incapacitated. So the main reason people use that trust is because the trust owns the assets, you avoid probate. So there you go through trust administration, and the court doesn't have to be involved at all. That keeps it private, and it can happen as quickly as your family wants, and it typically is much easier. So you keep your family out of court and out of conflict. You have more control. I find it can be more flexible because, for example, retirement accounts can name the trust as beneficiary. You just have more assets to work with depending on your distributions. You can ensure that your children do not inherit outright at 18. We can usually do that with a will as well. Just create a trust upon your death, but definitely with a trust you can decide when you want your children to inherit and how much, or you can even keep a trust for them for life that maybe they would control someday, but there's some advantages to doing that. With a trust, this is a trust created after death, but you can limit distribution. So if you have a child or another beneficiary and you're concerned about their spending habits, perhaps, whether that's because they're young or just have a bad history of spending, or if they have been involved with substance abuse in the past or now, you can leave them assets in a trust with however much control you want to set up. So you could name a friend or family member as to manage those assets for their benefit. You can name a company to do so. You can require that they have drug tests or that they have a job to keep access to the trust. Whatever you want and you're comfortable with is something you can do with planning. And then with a trust created for a beneficiary upon your death, you can also provide asset protection. So a living trust is a revocable trust, revocable living trust, but you can leave assets in an irrevocable trust that then would be protected from your beneficiary's creditors. And that can include divorce. So if you want to leave assets to your daughter and make sure that if she ever got divorced, that they would not go to her spouse, you can do that through planning upon your death and how you leave assets to your daughter in that scenario. If you do have any minor children, something I think is also important to think about is what happens in the short term. I have a mentor who guides a lot of how we run our business. I've learned a lot from her. And when she was starting out, she had young children at home. She had her trust set up and everything put in order, but she went out on a date with her husband, left the kids with a babysitter, very young kids. And she realized that if they were in a car accident on a very practical level, the babysitter would call the police would show up, and in the time it took to find those estate planning documents, to figure out who was the guardian named and what was going to happen, during that period of time, the police would have probably no option other than to put our kids in state's custody. So maybe a very nice family, but still strangers to the children. And so she created a kids protection plan that includes short-term guardian nominations. And that's just a notarized or witness document that says, these are the people in my local community that if something happens to me, I want them to be called to take care of the children. And then you would leave those instructions with a babysitter and also send to the people nominated so that they would have it with them, and even instruct the babysitter that, hey, if you don't hear from me, call these people first, get them there before you call the police. So hopefully your children will at least be with people that they knew in that scenario. Couple of other things we do have on that note, sorry, going back to the kids protection plan, we have a free resource. Alex just shared the link to that, and you can create some documents on your own and learn some more there. And we can send out those links as well if you can't capture them. There's a couple other things that I just like to highlight, what I call issue spotting. So just let you know it could be a thing that you're interested in, and then we can talk more if it sounds like something you should learn more about. So first is community property. And what I'll say, community property is extremely complicated, and it's really a tax consequence. But some states are separate property states. Some states are community property states. That's a term of art that doesn't quite mean what you probably think it means based on how it sounds. In Alaska, we are a default separate property state, but you can opt in to own property with your spouse as community property. The advantage is that when one spouse dies, any assets jointly owned get what's called a full step up in basis. So that if the surviving spouse sells the asset, they will pay no capital gains or capital gains from the date of the death of the spouse on. So what I usually say to simplify is that if you're married, if you're planned to stay married, because if you own property as community property, there can be negative consequences in a divorce. So you're married, you plan to stay that way, and have highly appreciated assets, so significant growth since you acquired them, then you may want to own property as community property to just kind of as a hedge, so that if one spouse dies, the surviving spouse could save a lot of money on taxes, depending. So there's my very quick spiel. And then thinking about long-term care, I should have the statistic on the top of my head, but I know it's over 50% of us will end up in some type of assisted living or care, need some type of hands-on care before our death. And I'll have to get to just quickly, is community property the same as owning assets jointly with right of survivorship? Not necessarily. If you have an agreement, a community property has to be a specific community property agreement, probably recorded. So if you have that, it might say survivorship community property agreement, but it would be different than, say, a it'd be different than owning property jointly with your spouse with right of survivorship. That just means that your spouse gets the entire property upon your death. So that was a big maybe. We can talk about more directly to your situation. And then there's a question, does the basis update also apply to a 1031 exchange? That may be an accountant question, but I don't see how. Oh, I see what you're saying, because you're rolling money into a new property to avoid capital gains. That is a good question, and I do not know the answer, because does the basis, that's a great question. I'll ask an accountant. And then email me if you want the answer, because I'll probably lose track of it. Okay. Coming back to this slide in the long-term care discussion, if you do end up needing long-term care, you can run through quite a lot of assets very quickly, especially in Alaska, and especially in an Alaska nursing home, which is going to be run at least $20,000 a month, I think, is the going rate up from there. So with planning for long-term care insurance can help. Often doesn't cover fully what someone would need. And what I do planning, it's called elder law, but we can plan around long-term care to protect some assets. So that if you do need long-term care down the road, you've put assets aside so that they are going to go to your family, and not if you need long-term care and end up wanting to turn to Medicaid to pay for care, you can protect some assets for your family. And if you needed long-term care on an emergency basis, we also do some planning around that. There's some ways that you can protect some assets and still qualify for Medicaid. Okay, I'll leave it there as just a small note about that. Incapacity planning. If you ever were unable to make your own healthcare or financial decisions for the short term or the long term, I recommend that anybody 18 and over have both a power of attorney for financial decisions and a healthcare power of attorney. There's lots of different names for the healthcare documents, but someone to make those decisions for you. For the meantime, until you get better documents in place, or if you know someone who's 18 or around there, there are free state forms for both healthcare and financial powers of attorney that they do have to be notarized, or I recommend you get them notarized, but you can print them and fill them out. There's links in the chat box. We can send those to you as well. I use slightly more robust, but these will work in most situations and can be done on your own. I've also provided a link here to 5 Wishes. That's an organization that I like, and some people prefer their advanced directive forms. That's the healthcare. And there's our legal as well. So you can choose to use that or the state's form. The state, I don't like our form. It's confusing. So you might prefer the 5 Wishes. All right, I'm nearing to wrapping up and opening it up for questions. But one thing I think that it's important to consider is, if you had to choose between the people you love receiving money or values, insights, stories, and experiences, what would you choose? we try and think about really the full legacy perspective, and thinking about how to leave some of those stories. We offer a legacy interview for all our clients with all of our packaged plans, where you can share your stories with family. And there's lots and lots of resources out there. My grandfather wrote his life story near the end of his life. He wasn't that old at the time, but I'm so happy he did, because I didn't necessarily listen or quite grasp all of his stories of his amazing life. And so now to have that resource to turn to is really valuable. There's also a company called Storyworth. You may have seen ads around the holidays, but they send, you sign up, it's quite cheap service, and they'll send an email out to you or someone else you want to sign up every week, and they can just write a paragraph. And then by the end of the year, you have a whole book. So lots of options out there. Just something to think about. We find that clients actually often don't want to do the legacy interview because they're worried that they'll choke up or not say the right thing, not prepare enough. But when we've seen them available after someone dies, people just like seeing their loved one. It could be just a mess of nothing, it doesn't matter what you say. It can matter, but I think just getting it out there is great for your loved ones. All right, my opinions on when you might want to work with a lawyer. One thing about estate planning is that you don't know if it's going to work until after you pass away. So that may give you comfort because you're not going to be here, but it can also be a reason to make sure it's done right the first time. So one reason I think is that working with an attorney, you have added assurance that people you love stay out of court and out of conflict. And I'll just say, of course, this is our business, but I also see how complicated it can be. So that comes from that as well. Not that everyone needs an attorney, but I do. Another reason is that if you want the people you love to have someone to turn to when something happens to you, so to guide them through the estate administration process. Sometimes it's easier to hire someone if you've had it on your to-do list for a while. If you want to create a trust, I highly recommend working with an attorney. I have yet to see a kind of DIY trust that is going to work anywhere near what they planned on or how they want it to work. If you're unmarried, there's no legal rights for the spouse. It can be a good time to work with an attorney. Blended families, there's some creative things we can do so that you can leave, if you want, all assets to your spouse, but then make sure that your children will inherit after they pass away, the spouse. Anything unique situations, of course. With that said, there's some free resources on the court's website. These are geared towards probate, but actually just very helpful to give you an idea of the process. Alaska Legal Services has some. The library in Juneau was doing quarterly presentations by estate planning attorneys. They've talked to a lot of us in town. I don't know if they still are, but you can find recordings. And at the beginning of those presentations, someone from the library was introducing they have some drafts that people can use. It's a good system if you're gonna DIY. It's not going to cover a lot of the what ifs. I think that's kind of the other. I often hear from clients of, oh, I didn't think about that. And that's, I think, our job is to help you think through the different layers. But for just a basic plan, the library has some good resources. All right. So you've heard a lot this evening. And I'd ask you to take a moment to consider what's most important to you. Perhaps you are put at ease because you're comfortable with what would happen upon your death. Or maybe there's something out there. And what is it that's most important? Do you want to make sure you're providing asset protection for your children or determining how and when they're going to inherit? Maybe you want to make sure that your family will avoid probate, whether that's because the time that it would take or the cost or for privacy reasons. And again, I encourage you to write that down, what the top would be. And then I want to talk about what your next step is. So you took the first step, getting educated by coming here today. And then what's next for you? If you're thinking, well, what would happen in my particular situation? Would my family end up in court? Would my assets potentially be lost? If you're thinking that, my solution is a life and legacy planning session with me. That's a 2-hour working session that I can do virtually from wherever you are, or in person if you're in Juneau. I also have a travel schedule I've put together for most larger Southeast communities. So if you're somewhere else and want to meet in person, let us know. During that life and legacy planning session, we schedule it 2 hours and we sit one-on-one to get questions answered about your particular situation. So we look at the assets that you have, you share the family dynamics, I tell you about the law, and together we look at what would actually happen to the people you love if something happened to you. Then during that meeting, if you want a different plan, you would tell me what about that plan works for you, what doesn't, and then together we would choose the best estate plan for you and your family, both from a cost perspective and an outcome perspective. Now, even if you think you're comfortable with what would happen, I do invite you to take the next step to do that life and legacy planning session for peace of mind, knowing you're comfortable with what would happen. And it is a very low investment on your end. Normally that 2-hour meeting is $750 because it's a 2-hour working meeting. But because you're here this evening and getting this education, putting some thought into it, and if you agree to do some homework ahead of time, which is important it's a part of the homework. Most of the homework is gathering your assets, which is important whether we plan together or not, so that your family has an idea of what you have. So if for coming here, I offer that meeting for free, as long as you do the homework, and that's good at any time. As an added incentive, especially as we come up on the end of the year, if you schedule today and schedule by your initial appointment by the end of February, then I will also give you $250 off if you decide to plan with us. So that's $250 off if you sign up this evening and schedule that appointment by the end of February. And I would do at least mid-January. I'm not sure how many we have open left in January, but and that is just an added incentive, thinking about if this is something you want to get done this year, then that's your motivation to get signed up, and we'll have that meeting. There's no obligation, of course, to plan with us. It's just if you do, we'll give you an extra $250 off. So to schedule that appointment, the link has been posted. It's a bit.ly link, Life and Legacy Planning Session. You can use that. You'll also receive, probably in a few minutes in your email, an email with the link. Now, you may be planning with someone else, a spouse or a partner who's not here listening, and you may have to talk to them and explain why this is something you want to do and talk through their schedules. So if you sign up this evening and then have to move it later, we'll give you one reschedule. I think I already said schedule at least 2 weeks out to give yourself time to do the homework. Unless you're really motivated, that's fine. We have clients that get it done in a few days, but we do ask for it, at least the homework, back to us 3 days before the meeting. So once you sign up, we'll get that out to you pretty quickly. And you should, I think Alex's email is alex@lizsmithlaw.com. I think we're pretty easy to get a hold of, and you'll have lots of emails from us. Okay, you can definitely, of course, do the meeting later for sure. Just mention that you attended a webinar and you'll get the free meeting, just not the $250 off. And okay, quickly before questions, I'm just going to talk about our process and what that looks like so that you have an idea. I hear that attorneys can be intimidating. I hope I'm not, but I like to give an idea of the process because I think if you have that in mind, then it could make it less intimidating. All right, so you book your appointment We're going to make sure we get your address from you, your mailing address, other information. We have a link we'll send out for some additional information. And then we'll mail out a pre-meeting packet. And we're also going to send out the inventory. We have a link to fill it out online. And that inventory is your homework, an inventory of assets, family information, and fill it out as best you can. It does ask for who you would want in certain roles, but that's just an idea of what you're thinking about now, nothing final. Then we have your life and legacy planning session to look at what would happen now. And then you decide if you want something different, and we would design your plan in that meeting usually. Signing happens about at least 4 weeks after the design of your plan, figuring out what you want to happen. After signing, we offer that legacy interview if you would like to do that, optional but encouraged. And then we schedule a final binder delivery meeting. So that meeting, you will have either transferred assets to your trust or changed beneficiaries if needed with a will plan. And then we just want to make sure that's all been done. You actually get your documents at that meeting. And we talk about some of the next steps. And then we do a lifetime of follow-up. So at least every 3 years, we do a free review. And that's just looking over to make sure the plan is still up to date and what you'd want to do. And we have that annual option for members. If you work for the government, they may have some free legal benefits with the state of Alaska or IBEW. These are some that we work with. Oops. And thank you for coming this evening. I'll open it up for questions. I see a couple in the chat, and if you found this interesting and think others might, we'd love you to send them our way. In 2023, I'll be doing, I don't know, maybe 9 webinars throughout the year, but I'm doing a lot more in-person presentations throughout Southeast. If you know anyone who would want to do that, they can check our website eventually. All right. Let me